Hello friends, in the series on the income tax cases, today we will discuss the importance of section 264 and the issue which is involved in the present case is that if an assessee goes for revision application under section 264 after a long period, the basis of delay in the application of section 264 is that because for another year in which the matter of the assessee was on the same issue and the CIT appeal takes a very long time to decide the matter, and assessee on the basis of the CIT appeal order chooses to go for revision application under section 264 for another year, and the CIT appeal rejects that revision application only on the basis that this is delayed. So whether CIT has the power to condone the delay in filing the revision application. This issue has been taken up by the Honorable Bombay High Court in the case of Hindalco Industries Limited versus Union of India and another, and this case has been reported in 464 ITR at page number 236. The date of the judgment is 17th January 2024. In the present case, the matter was related to assessment year 7-8. The issue which was in the assessment year 7-8 and the issue which was in the assessment year 9-10 was identical. The assessee was before the CIT appeal for the assessment year 9-10 on a limited issue that whether fringe benefit tax to be paid on some items or not. CIT appeal, after taking a long period of near about 6 years, decided the matter in favor of the assessee that fringe benefit tax is not payable. When the assessee received this order after 6 years, the assessee realized that for the assessment year 7-8, the assessee has paid some fringe benefit tax which is not actually payable by him, and now which has been confirmed by the CIT appeal in the decision for another year also. The assessee filed the revision application under section 264. Section 264 gives the time of 1 year from the receipt of the order to file the revision application. The revision application can be filed by the assessee, and the CIT has also the power to do the revision under section 264. But friends, section 264 prescribes those cases in which the revision can be done which is prejudicial to the interest of the assessee. So I have never seen in my life that any CIT has done the revision in favor of the assessee under section 264 by suo motu. It also shows the narrow-mindedness on the part of the income tax department, that they never feel that something wrong has happened to the assessee or some tax has been collected not as per the law. But that is a different issue. And the reason why the assessee do not choose for section 264 is that if he opts for revision under section 264, then he loses the right to go to the CIT appeal. So if the CIT rejects revision application under section 264, that is not an appealable order, but the assessee can go in the writ court if the revision application is rejected outrightly or without any reasons. So in the present case, when the assessee filed the revision application under section 264 on the basis of the CIT appeal order for the different assessment year, and that too was not in time, the CIT rejected the revision application on the basis that it is not filed within 1 year from the receipt of the order. So he rejected the application. The assessee filed the writ petition. When the Bombay High Court looked into the matter, the court said that in the present case, the revision application should be considered on merits, and it was not the fault of the assessee that he has come late to the CIT, because the CIT appeal has taken 6 years to decide the matter, if this much of the time will be taken, then it is not in the control of the assessee to file the revision application within time, because if the decision have come in time, the assessee has chosen to go for the revision application at an early stage, and if some relief has been given to the assessee on some issue, and same relief is also to be given to the assessee for different assessment year, it is well within the right of the assessee to file the revision application. So the Bombay High Court quashed the rejection order of the revision and directed the CIT to consider the revision application of the assessee on merits. Friends, this case is very important because it may happen in the practical life that for 2-3 years the matter is in dispute, but the assessee chooses or is in appeal only for 1 year. So if he gets the relief in 1 year, so on the basis of that relief, he can knock the door of the CIT under section 264. At the end of this video, once again I am repeating the name of the case. The name of the case is Hindalco Industries Limited versus Union of India and another. And this case has been reported in 464 ITR at page number 236. The matter has been decided by Bombay High Court and the date of the judgment is 17th January 2024. Thank you, friends.